Good afternoon. My name is Lauren Lambert. I'm the attorney here at Arrow Legal Solutions. And today I'm going to explain a few things that you need to know about your upcoming Social Security hearing. After you listen to this briefing, I will then be able to talk to you individually to ask or answer some individual questions you may have, and also to give you a little bit more detail about the proper way to listen to and respond to questions during an Social Security hearing. One thing that you need to know off the top is that it's an informal setting. I don't want you to get wound around the axle or overly nervous about what I'm telling you. Just listen, take to heart what I say, and try to do the best you can. Most of these cases are won based upon the medical evidence, and rarely is your case necessarily won because of what you say, but it can be lost. But it can help in those cases where your testimony is very important in deciding some of the areas of your case that are a little bit difficult. But again, the bottom line is listen to what I have to say, take it to heart, try to do the best you can, and that's all we can expect. First thing I want to talk about is when you come to the hearing, you need to be cordial to all the personnel that you meet there. You need to speak clearly and honestly when you're asked questions. And what you wear is, I want you to come dressed as professionally as possible, very comfortable, conservative clothing. Very rarely will I ask a client, in fact, I've never done this, I don't ask clients to dress down. But then again, I don't expect you to come in a suit and a tie if you don't typically wear that kind of attire and you don't have that kind of attire. But well, come comfortable with clean and laundered clothes. If you do have a collared shirt, you can wear a white shirt with a tie, or if you're a female, again, wear something that is comfortable, conservative. Don't have anything that shows cleavage. Also, and this is very important because it's a weird thing about human nature. Human nature is such that a judge may consciously or subconsciously hold it against you if you come to a hearing wearing expensive jewelry, if you've had an expensive hairdo done, if you come with expensive shoes or your nails done. A lot of judges do not understand, and also a lot of expert witnesses do not understand that sometimes for a female especially, those are the most important things. And you may have somebody else do your nails or do your hair as a favor, and it may have nothing to do with the resources you have or don't have available to you, and it may have nothing to do with the energy level that you have. But to avoid having somebody consciously or subconsciously have a bias against you, do not have your fingernails done up, do not have your fancy hairdo done, don't wear jewelry. The most jewelry you should wear is one ring, a wedding ring or a wedding band, and single prong earrings. Don't wear a lot of makeup, very little makeup if anything. If you want to wear makeup, you can maybe do a little eyeliner and a little something on your lips, but that is all. This is not a contest to see how well you can look in front of the judge. It's just the opposite. You're here asking for benefits from the judge. So don't do any of those things. And I said don't wear perfume, because perfume can get in the way of what you have to say and can irritate people that have sensitivity to that type of thing. The other thing that's important for your hearing is to make sure that we have all your medical records. We have every step of this process tried to make sure that you've identified all your medical providers, your doctors that you've gotten, and we've been able to get if you couldn't get all of your medical records. You need to check with us again one last time to make sure all of the necessary medical records have been obtained and have been submitted on your Social Security case. Now, if you haven't been able to get certain things, we can ask that the hearing be left over and we can get those medical records, so don't panic. Also, at times, other records may be important, such as counseling records, school records, records if you've had any kind of a criminal history when you've been evaluated, records from jail, records from probation, vocational rehab records, any kind of alcohol and drug rehabilitation you've had, accident reports, photographs, videos, all things that you may think may help demonstrate what your condition is, may be things that we want to provide to the judge. If you're curious about those kind of things, just ask me. The next thing you have to know is that at your hearing you will be asked to describe your condition. That may seem elementary, or that may seem to go without saying, but you'd be surprised how many times I have clients, even after I have this conversation with them, that aren't able to describe their condition and how that condition affects their ability to function. You're the only one that lives in your body that knows what it's like to experience the kind of conditions you have. Don't assume that just because a judge or another human being has been in this world and has had pain and sickness in their life that they understand what you're going through. There are people in this world that may go through an entire lifetime with hardly ever being sick and hardly ever having any problems. They may not understand what you're going through. You have to be able to describe your problems and your conditions and how they limit your ability to function. So you need to think about that. If you have pain, you need to think about where the pain is, how strong the pain is, how long the pain lasts, what causes the pain to be worse, what causes it to be better. It's not good enough just to come and say, well, I hurt. Everybody hurts. Everybody has problems, especially individuals who live a life that is very active and get to be over the age of 30 or 40. You need to describe specifically how in your life your conditions affect you. And that goes for conditions of pain, fatigue, if you're depressed and have a hard time being motivated, if you have a hard time with your emotions, you need to be able to describe all those things and how they affect you. The one thing that is very important in the hearing is that you don't minimize or you don't exaggerate your symptoms. A lot of people will exaggerate their symptoms because they're afraid of not being heard. Therefore, they think they have to do that in order for somebody to take them seriously. Do not do that. Do not exaggerate your symptoms. Say it how it is. No more, no less. Very rarely at times I get clients, and this has happened, that they have this idea that they don't want to be embarrassed, so they start minimizing certain things about their symptoms. No, don't do that. If your symptoms affect you in very embarrassing ways, you need to talk about that. This is not a popularity contest. We are there asking for benefits. And let me also talk about that asking for benefits. If you go into a hearing with the attitude, these are my benefits, I've earned them, you need to give them to me, you're not going to get them. Your attitude, even though that may be true, your attitude has to be, I've done everything I can, I've worked hard, these are all my problems, Your Honor, and this is why that you may decide that I need these benefits. We don't come in there demanding. We actually come in there almost prostrate, begging for these benefits. And again, it's not begging to the point that we're not truthful, but you can't come in there with an attitude, because judges pick up on that and they react negatively towards it, even though that may very well be your right and you may very well deserve those benefits. Now, along with not exaggerating, many times judges will ask you certain questions. For instance, you need to be aware of why they're asking you those questions and what is the appropriate way to answer them honestly. If you are asked to give a level of your pain on a scale of 1 to 10, make sure you understand what that 1 to 10 means. Usually it means that a 10 level of pain is that the pain is so bad that you are screaming, you're passed out, or you're in the hospital. In other words, you've had a limb that's just been severed, you're going through childbirth, you've just been crushed. Those are the kind of things that bring people's pain to a level 10. I've never had a client who could legitimately, within a hearing, say that their pain was a level 10. And even after having this discussion again, I've had clients who are asking for benefits say that. Now, Were they lying? No, I think in most cases the clients were not lying. What they were doing is they thought that they had to exaggerate things in order to be considered credible. Moreover, there's a lot of people that they just talk in that kind of a fashion. It's normal for them to say, oh, I just heard it's like a 10, it's like a 10. Well, again, keep in mind that you being expressive is different from you trying to be analytical and describing your pain how it really is and how it is to the rest of the world. Don't come into the hearing and say your pain is a level 10 when you're not screaming, asking for drugs to keep the pain down, or you're passed out, and of course you wouldn't be testifying at all, or you're asking to be taken to the hospital. Most people's pain at its worst is around a 7 or 8. Know when your pain is at its worst, 7 or 8, what causes it to get there, when and during what period of the time of day does it become at that level. Know when it's less, know when it's at its very least, 3, 4, or even no pain, but be able to describe that and describe that with some sort of validity. You may be also asked about, as I said, symptoms like depression or fatigue. Make sure you're able to describe those. For instance, if you say your depression is at a level 10, usually that would mean that somebody is totally unable to function at all. They're either bawling out loud and can't stop, or they're unable to even get up in the day. Same with fatigue. Make sure you understand what that level it is, but don't exaggerate or minimize your pain, your fatigue, or other symptoms that you are having. You'll be asked your work history, meaning what jobs you have had for the past 15 years, and sometimes that's not necessary, but just be prepared to describe what your work history has been. If you need to look at records that you have, tax records or other information, make sure you can remember what jobs you have had. Now, you're not going to a job interview when you're going to get your Social Security hearing. The reason that you're asked about your job or jobs is to understand what you've been able to do, what skill levels you have developed, and what types of activities you engaged in during those jobs. You're not there to exaggerate how wonderful you were in the jobs. You're just there to explain what you did. Do not, and one other thing, be careful about what you're asked. For instance, I've often had people asked if they supervised anyone. That does not mean that you were tending children and supervising the children. A job as a caretaker does not mean you're supervising. Supervising means you're instructing other people how to do their job and making sure they are doing their jobs. So again, make sure you understand the question. You will be asked about each impairment and condition you have and how that affects you. And again, that kind of goes along with the symptoms. So understand what are all the conditions that I, as your attorney, are going to be saying that you have, and understand how those conditions affect you, whether it's headaches, diabetes, back problems, gastrointestinal problems, nerve problems, mental health issues. Understand how each impairment, condition, illness, or disease you have affects you, and be prepared to talk about them. Think about how they affect you. Think about how they've impacted your life. Sometimes it's difficult to remember how we were when we were healthy, but think about that and be able to explain and articulate how your conditions affect you and how they prevent you to function at a level that would allow you to work. You may be asked, well, you will be asked in most cases, how long your conditions prevent you, or how long you can, even with those conditions, do things like walk, stand, sit. And you need to have answers for those things. Have in the back of your mind that if you express, and I'm not telling you to lie, and I want you to understand that. I just want you to understand what's being asked here. If you can jog for several miles, we probably need to talk about whether or not you're really disabled. Now, there may be other things like mental health issues that while you can be very physically active, your other issues prevent you from being able to be competitively employed. But you need to think about how long you can walk, stand, and sit. Now, along the lines of not saying your pain is at a level 10, don't come to the hearing and walk from the parking lot unaided or without a cane or without somebody putting you in a wheelchair, and then walk through the hallways of the Social Security Administration and walk into the room, or don't go to the store and walk for a half hour at a store getting groceries and then come to the hearing and say you can only walk for 20 feet. Think about how far you actually can walk. Now, you also need to think about the pace at which you can do certain activities. If you can walk very slowly, then you need to explain that is, while you can walk a certain distance, it is very slow. If you can walk on occasionally because you have good days, and sometimes you can walk fairly far, but you have problems the next day, you need to be able to explain that. Don't come to the hearing and sit before the judge for 45 minutes without getting up, or an hour or 2 hours, however the time may be, and then say you can only sit for 15 minutes. You'd be surprised at how many clients that after having this discussion, come to a hearing and they will sit before the judge for an hour, and the judge will ask them, well, how long you can sit? And they'll say, for 15 minutes. Now, the judge in asking that question may not have said, well, how long can you sit without pain? Because sometimes that's what I'll have clients say. Well, I thought he meant how long can I sit without pain? I just sat there because I thought I had to, but I was in a lot of pain. No, listen to the question and answer it. If it's how long can you sit without pain, then answer that. If it's just how long can you sit, the judge didn't qualify his question with whether or not you were in pain. Also, don't come to a hearing and when the judge asks you how much can you lift, don't say I cannot lift anything. If you've been lifting up your arms, that is lifting something. If you can carry a purse, that is lifting something. If you can carry a half a gallon of milk, that is lifting something. The judge is literally asking you how much you can lift. So you need to figure that out before we get to the hearing. Try lifting up a few things. Moreover, the case may be that if an emergency occurred, you could maybe lift up to 50 or 70 or even 100 pounds. But if you know that could injure your back or set you back a few days or cause significant harm afterwards or significant pain, you indicate that. It is okay to give an answer like, well, if there was an emergency, I could lift at the most up to 50 pounds, but because of my back, I couldn't even do more than that, even if an emergency required it. Or something to the effect of, an emergency, I could lift this, but I can't do that with any kind of on any kind of a repetitive basis because it causes me problems, causes me to be in a lot of pain, and then I can't think and function. So be aware of that. You may be asked those sort of things. How long and at what level and at what pace you can sit, stand, or walk. You will be asked how much you can push, pull, and lift, as I've already indicated. Find out how much you can do those things and qualify it if you need it. You may be also asked, how long can you concentrate at a movie? Or do you read? Or can you drive? Or can you comprehend a conversation that's going on? Think about those things, and if that's one of the areas where you have difficulty functioning, be aware that you're going to be asked those types of questions. You may be asked what your typical day is. When you're asked that, what your typical day is, that would mean the days that you usually have. It would be excluding the bad days and the good days. If you're asked what is your bad day, what are your bad days like, be able to describe that. If you're asked what are your good days like, be able to describe that. Be able to describe how many good days and how many bad days a month you have. Think about that. Describing your day means what you do from the moment you get up till the moment you go to bed, and when those types of things happen. When do you get up? When do you go to bed? When do you eat? What types of meals you make. Now, keep in the back of your mind that the reason you're being asked this is because sometimes your level of activity would indicate that you could work full time. The reason I'm telling you that is, again, I'm not telling you to lie, but I'm telling you to understand that what you may have been able to do 5 or 10 years ago, which only took 15 minutes, now takes an hour or 2 hours. So just saying that I vacuum is not as expressive as saying, well, I used to vacuum the whole house, once a week. Now I only can do it once a month. And when I do it once a month, it takes me 5 days. That's the kind of detail that you need to give to help illustrate how your conditions affect your ability to function. You may be asked about alcohol and drug use. If your records indicate that you have any alcohol and drug use, what the judge wants to find out is your alcohol or drug use such it's risen to an extent that if you stop that alcohol or drug use, you would be able to function and work. Because the rule in Social Security is that if you can function without taking the drugs or alcohol and work, then you will not be found to be disabled. Now be aware of a couple things. Most people that have had substance abuse issues, there are usually some of their doctors who know all of those details. I can get, and I've had many administrative law judges, and all administrative law judges across the country do give benefits to people who have alcohol and substance abuse issues. However, if you lie about those substance abuse issues that are in your records, then the judge will, a lot of the time, and my experience has been almost all the time, find you to be uncredible and you won't get your benefits. You need to be completely honest about that. If you come thinking that you can deceive the judge, it very rarely happens. So you need to be honest, you need to know what's in your records, you need to be able to truthfully discuss those conditions. Now the other reality is that most people that have alcohol and drug abuse issues usually have a lot of other problems. And sometimes those other problems are what cause them in some ways to have those alcohol and substance abuse issues. It's a human condition that is well understood by many of the judges. So again, this is not a popularity contest. You're not at the hearing to make yourself look good. You'll need to discuss those things and you'll need to do so honestly. The next issue is whether or not you've been compliant with your medical provider's treatment recommendations. The law in Social Security is that if your doctor has made treatment recommendations and those recommendations are reasonable and you can afford them, and you haven't complied with those recommendations, then the judge has to decide that if your non-compliance is what has caused you to be disabled. Be aware of that so you're able to discuss why certain treatments you didn't follow. That your response may be, well, I tried that treatment and it made these other things worse. Where I tried that medication and then I had these negative reactions. Or, yes, I would love to get that back surgery or that shoulder surgery, but I have been unable to afford it. There may be various explanations, but you need to be aware that that can be an issue. Another thing, along with being honest, don't drive your vehicle to the hearing and then lie about your ability to drive. If you can drive, explain that. If your driving is limited, if you have to take breaks if you go on drives, then indicate that. If we are having witnesses come to your hearing, make sure that you and your witnesses have discussed what activity levels that they know that you've been involved with. I'll get a lot of times where clients will forget they have been on vacation. Now, going on vacation does not mean that you are not disabled. With today's modern conveniences, people can go on vacations and have a very low activity level in getting to the airport or driving in the car and arriving, and they might be just staying in one place kind of visiting, as opposed to somebody who goes on vacation and gets involved in all the different activities that you can do while on vacation. So again, going on vacation is not something to lie about. If you've gone on vacation, if you've done certain things, you need to be able to describe what it is you have done to put it in context, and make sure that you recall what you've done, so you don't have a witness coming to a hearing and remembering that you went to Disneyland and went on all the rides and swam in the pools and then went surfing in the ocean. And of course that's not true with anybody I've ever represented. But if you've forgotten that you even did that, it looks like you have something to hide, and you may need to describe that. You may need to describe, if you drive to St. George to visit your relatives and stay with them for several weeks, that it takes you 10 hours where it used to only take the 5 or 6 hours it takes today because you had to stop and rest. So make sure you know what those activities are. Make sure you know, if you socialize and do other things, that you can describe how what you do is different from what other people can do. Lastly, you should, if you haven't, again, you should read your case file. You should know what records are in your file. You should read your medical records so you remember what your medical history is. And so you should have some memory of the things that the judge will be reading and reviewing to determine whether or not you are disabled. That is all of this presentation. I will talk to you a little further in person and answer any questions and have you try a few sample answers to some questions that I will give you. Again, don't be nervous. Just take to heart what I've told you. Oh, one other thing. If you can not take your meds on the day of the hearing and do so safely, it won't hurt you in the long run or set you back. And that depends on the types of medications you're taking. But if you can avoid taking pain meds or other things so you can describe more distinctly what it is that you sense when things are at their worst, I would encourage you to do that. However, if you can't do that safely, if it sets you back and has an adverse effect on your health, take your meds as you're required. It's probably important to bring a copy of all the medications that you normally take in case you're asked about those. But anyway, wrapping this up, I'll be prepared. We'll be prepared to put on your case. Please think about the things that I've told you and be ready for your hearing at the time that we're having it. And if you have any questions, write them down and I'll make sure that I answer all of them. Thank you very much, and I'll see you shortly.